August 18th, 2025, Deidre Baumann, Baumannesque@gmail.com, Baumann and Schuldiner 77 West Wacker, Suite 4500, Chicago, Illinois. 60,601 subject, termination of legal representation. Dear Attorney Baumann, please acknowledge this letter serves to formally notify you that I am terminating your legal representation in the matter of Dreyfus et al. v. Maxson et al. Case number 2,025 Swiss francs, 197 effective immediately, which contractual agreement is expressly to provide defensive legal counsel and services. The terms of agreement included not less than your making timely informative conveyances, appearances, filings, etc. on my behalf, and keeping me abreast of all such actions and intent necessary to continue and secure remedy in an ongoing pursuit of a settlement award in the amount of $312,000 plus, pursuant to amending the case to include a viable quantum merit claim. Further, I have decided to discharge your duties due to blatant ineffective assistance of counsel and demand you cease in decease from all representation and/or negotiation on my behalf. More specifically, to end all exchanges severally and/or collectively with Mark Maxson, Elliot Zinger, Larry Dreyfus, and their respective counsels regarding this case. As an officer of the court, not adhering to judge's orders and failing to file counter responses to opposing counsel claims is woefully egregious. As a result of such malicious negligence, coupled with your failure to respond to my repeated outreach to discern your pending strategy, status of case filings, inclusion of evidentiary material I requested, confirmation of intent of appearance, or at the very least, opting to motion for a continuance of hearing is wholly professionally inept. As a matter of record, sufficient material fact of all pertinent concerns regarding such lack of your requisite legal actions and duly procedural duties are shown in pleadings and transcripts. I have delivered you a preponderance of substantive documentation to prove the worthiness of my claim with profound due diligence. Consequently, in our final exchange, your admission of comprehending failure to comply specifically denotes that by not filing stands to cause undue, unfavorable, and adverse burden to the integrity of recovering compensation set aside as a result of such non-response to opposing counsel's brief is worthy of counsel review. And also, maliciously opining a $30,000 settlement offer by opposing counsel, obviously for their benefit, as well as expressing full discernment, your disregard of obligatory response avails an opportunity for opposing counsel to depose me, which facilitates an undue prolonging of what should reasonably have been construed for all practical purposes to have probability if an otherwise informed, favorable disposition be determinable of the trajectory of this matter. Lastly, as you have fulfilled 2 appearances and administered 2 filings under the terms of our agreement, my ask is for the return all communications and record exchanges between all parties, including written, oral, emails, phone logs, texts, case files, etc., and all other documentation which I provided to you relative to this matter. Please invoice said appearance and filing fees at your earliest convenience. Thanking you in advance. Respectfully submitted, Wallace R. Bradley, Urban Translator.